Ever pondered the weight of history in shaping our present and future? Or how the echoes of past events resonate through our lives, societies, and cultures? Today we delve into a significant chapter of Canadian history, a timeline leading up to the appeal hearing aiming to repeal the Tamil Genocide Education Week Act of 2021. We start our journey in April 2021. The Ontario Legislative Assembly has enacted the Tamil Genocide Education Week Act, which is perceived as one-sided. This decision was made without consulting experts in the field or awaiting a declaration from an international court. This act commemorates the victims and survivors of the alleged Tamil genocide, aiming to educate the public about the atrocities that occurred during the Sri Lankan armed conflict. In legal developments from the Canadian community, the Sri Lankan Canadian Action Coalition and the Sri Lanka Canada Association of Brampton took a stand in June 2021 to question the legality of the Tamil Genocide Education Week Act. With the support of various community members, they filed a notice of application to the Superior Court in September of that year. A personal case was also filed by Neville Hewage. When the case was heard by the Superior Court in June 2022, the ruling did not come out in their favor. Subsequent to a series of community consultations and on the advice of legal counsel, as well as input from several well-informed consultants who raised concerns about significant legal flaws in the judgment, the community has decided to file an appeal. The grounds for the appeal are centered on the belief that the act in question is inherently biased and could contribute to division rather than promoting unity among the populace. This brings us to January 2023, when the appeal is officially lodged with the Ontario Appeals Court. The petitioners argue that the act promotes a one-sided narrative of a complex historical event. Fast forward to November 3, 2023. The date is set for the hearing. It's December 4, 2023. The court's decision will have a profound impact on how history is taught and understood in Ontario, and potentially throughout Canada and worldwide. We had the privilege of meeting Dr. Scott Fairley, the lead counsel, and Joan Casozi, member of the legal team in Ottawa, and here is what they have to say about the hearing on the 4th of December, 2023.
Basically, the arguments that will be presented to the Court of Appeal are twofold. First, as we argued in the court below, that the legislation under attack, the Tamil Genocide Education Week Act, is ultra vires the power of the Ontario legislature to pass, since it directly engages Canada's relations with a foreign country, and that belongs to the federal government. The case could be resolved simply on that ground. However, we've also argued that there are serious Charter of Rights implications that directly affect the Sinhalese minority diaspora in Ontario, in particular the effect of this legislation, which has caused public and secondary school boards, for example, to prohibit the Sinhalese point of view from being brought forward on the issue of whether a genocide occurred during the Sri Lankan Civil War or not, and that expressing such views constitute hate speech. That's a very serious allegation, and there are very serious consequences of this legislation, even though the legislation doesn't speak to it directly, and that's another important reason for striking it down. So those are essentially the two principal arguments. I think it's important for the community to understand that if the Court of Appeal were to accept our division of powers argument, that it need not go any further, and that the Ontario legislation would fall at that point. However, if for whatever reason the Court of Appeal doesn't agree with our submissions on jurisdiction of the Ontario legislature at first instance, then the charter issues must be addressed. The court could speak to both issues if it so chose, but it has discretion not to deal with the charter issue if it strikes down the legislation on division of powers grounds. So that's essentially the strategy we're going to be following. As in the court below, I will be dealing with the jurisdictional question, And my co-counsel, Nicholas Rouleau, who's not in Ottawa with us today, will be handling the charter issue, just as we did before Justice Akbarelli in the court below.
Thank you. Ms. Kasozi, could you explain to us what kind of procedural information pertaining to the hearing process on the 4th of December?
So the hearing will take place, as you said, at the Court of Appeal on December 4th. Thereafter, a panel of judges, there'll be 3 judges hearing the case. They may either deliver a decision at the day of the hearing, but what is more likely is that they will reserve their decision, and we expect to receive a decision within 3 to 6 months from the date of the hearing.
Dr. Fairley, given our work over 2 years on this case, what are your expectations in terms of possible outcomes, and what can we expect in the future moving forward from this case?
Well, once the Court of Appeal is decided, there is a fork in the road, if you will. If we are successful in the Court of Appeal, then the Attorney General of Ontario has the option to seek leave to appeal to the Supreme Court of Canada. Leave may or may not be granted. So it's a 2-stage process. If leave is granted, then the case would subsequently be argued in the Court of Appeal. If we are successful in the Court of Appeal, then I think the community or communities that we represent should seriously consider fighting that case to preserve the win, which is a very important precedent, not simply for your communities, but generally, in terms of a legislature essentially proselytizing or spreading fake news and putting that in a legislative enactment. That is the principal objection to the legislation we're attacking, in that it declares that a genocide occurred during that long and bitter civil war, when in fact the only expert evidence on point concludes that a genocide did not occur. And genocide is one of, if not the most, perhaps the most serious crime recognized in international law. So it's important to defend a win. If regrettably the Court of Appeal decides in the government's favor, then the communities that we represent, you, have the option of either basically folding your tent at that point and not continuing further, or seeking leave to appeal yourselves. Now that is it's a very important question, and I would urge you to give that serious thought, but I also appreciate the financial burden that your communities have assumed to carry the case this far without assistance from other sources outside your community. And
we also spoke to Mr. Sena Munasinghe, President of the Sri Lanka Canada Association of Brampton.
ආයුබෝවන් හිතවත් ශ්‍රී ලාංකික කැනඩියානු මිත්‍රවරුනි කලක නිහඬියාවකින් පසු බ්‍රැම්ප්ටන් ශ්‍රී ලාංකික කැනඩියානුන්ගේ සංගමය වෙනුවෙන් මාව බමතන්නේ ළඟදී එන වැදගත් අවස්ථාවක් මතක් කිරීමටයි. කුප්‍රකට දමිළ ජනසංහාරක අධ්‍යාපන සතිපනතට විරුද්ධව අපගෙන යන සටනේ ඊළඟ පියවර වන්නේ අපට විපක්ෂව ඔන්ටාරියෝ මහාධිකරණයෙන් ලැබුණු තීන්දුවට එරෙහිව අප විසින් ඔන්ටාරියෝ අභියාචනාධිකරණයට ගොනු කළ අයදුම්පත ලබන 4 වෙනිදා දෙසැම්බර් 4 වෙනිදා විභාගයට ගැනීමට නියමිතයි. එදින ජාති හිතයිෂී ඔබට අපට සහයෝගය දැක්වීම සඳහා එම උසාවි පරිශ්‍රයට පැමිණෙන ලෙස ගෞරවයෙන් ආරාධනා කරනවා. එම විස්තර යථාකාලයේදී ඔබට දැනුම් දෙන්නම්. ඒ සියලුම වියදම් දැරීම සඳහා මුල සිටම අපට අත දුන් විශේෂයෙන්ම මුල්නඩුව පරාජය වූ පසුවත් අප සමග රැඳී සිටමින් අප ධෛර්යමත් කරමින් අපට සහාය දුන් ඔබ හැමට ස්තුති කරන අතරම ඉදිරි කාලයේදීත් ඔබේ සහාය අප බලාපොරොත්තු වෙනවා. මෙම අභියාචනාධිකරණයේදී තුන් පුද්ගල හෝ පස් පුද්ගල විනිසුරු මඬුල්ලකින් අපට වාසිදායක තීන්දුවක් ලැබේයයි විශාල බලාපොරොත්තුවක් තිබෙනවා. නමුත් මේ නඩුව ශ්‍රේෂ්ඨාධිකරණය දක්වා යන්න පුළුවන් බව අපි මතක තබා ගත යුතුයි. ඒ කෙසේ වෙතත් මෙම ඓතිහාසික සටන මේ දක්වා ඉදිරියට ගෙනීමට හැකියවීම අපගේ ප්‍රජාව ලද විශාල ජයග්‍රහණයක්. ඔබ සමට ස්තුතියි.
We reached out to Mr. Anura Ferdinand, president of the Sri Lankan Canadian Action Coalition.
Hello everyone. We stand here today filled with deep sense of appreciation and hope. We are at a crucial juncture, one that holds immense significance for both our present and future generations. It is time where we strive for justice, for truth, and for the preservation of our history. Firstly, I extend my heartfelt best wishes to our legal team. Your expertise, dedication, and resilience are the bedrock of our quest for justice. As you step forward to represent our cause, you know that you carry with you our utmost trust and confidence. Your efforts are not just a legal endeavor, but a beacon of hope for so many. I must also express my profound gratitude to the executive teams of the Sri Lankan Canadian Action Coalition and the Sri Lanka Canada Association of Brampton. Your tireless efforts in raising funds and awareness have been instrumental in bringing us to this pivotal moment. Your dedication goes beyond mere organization. It is a testament to the power of collective action and shared values. To all our supporters, your unwavering commitment and enthusiasm have been our driving force. Your contributions, both big and small, have been vital in the journey towards justice. It is your belief in our cause that has enabled us to stand here today, ready to face with the challenges ahead. We are united in our goal to prevent the rewriting of history by those with pro-Elam or separatist agendas. This fight is not just for the present, but a crucial step in safeguarding truth for future generations. Your support has been the cornerstone of our progress. Without it, we would not have come this far. I also want to acknowledge the confidence you have placed in us. This faith is not taken lightly. It fuels our commitment to pursue justice relentlessly. As we approach the appeal case on the 4th of December, in just a few days, let us remember that our victory is not solely defined by the outcome. The fact that Cambridge LLP has filed an exceptional case supported by expert witnesses like Dr. William Shabas is a triumph in itself. This effort underscores our commitment to truth and justice. While our case and one other personal case are at the forefront, we had hoped for more. Yet, the strength of our cause is not diminished. We continue to support efforts to build bridges within our communities. We aspire to live in peace in Canada, away from conflicts that hold little relevance to our new generations. This does not mean we forget our past. Rather, we seek to recognize and adopt international and Canadian standards that educate our youth truthfully without indoctrinating with falsehoods. In closing, I thank each one of you again for your support and faith in us. I also extend my gratitude to those who challenged us. You have helped shape our legal journey in so many positive ways. And those who did not believe in us, your skepticism only fueled our determination to work harder. Together, we have already made significant strides, and we will continue to work towards justice, truth, peace, and harmony. God bless you all. Thank you.
The importance of historical education is undeniable. It shapes our collective consciousness, informs our present, and guides our future. As we await the outcome of this hearing, we are reminded of the delicate balance between remembering the past and fostering unity in the present. The question remains, how should we navigate the complexities of historical narratives in our educational system? That, dear listeners, is a question for us all to ponder.